Harrington here, folks. Leg is on the mend. By the time you guys watch this video, I should be back in my assigned seat in the Florida office, and thank you to the well-wisher. But enough about that. Today we are talking about depositions, as I promised that we would last week. Now, depositions, listen, I feel the same way you do. I don't really like them. I kind of hate them. I mean, they're tedious. They tend to take a whole day. They're expensive for the client. You got the two attorneys there flexing and trying to impress their clients. I'm getting too old for that stupid stuff. So I don't really like them, but that doesn't mean they're not very useful. And if we're defending a deposition, we don't have any choice. So let's get it on. Our Practice Makes Perfect is the podcast for business owners and real estate investors, siempre con un cariño especial para los clientes extranjeros. Part 1. I guess there are two aspects of depositions. One is defending the deposition, and the other is, taking the deposition. Let's do the taking the deposition because we can get that out of the way very quickly. I mean, after all, there's nothing for you to do as the client, right? It's the attorney's show, and all you have to do is decide whether or not you want to have somebody's deposition taken. As I said at the outset, I'm going to shoot you straight. Those things tend to be expensive. It tends to go the whole day. The attorney can't do anything else. It requires full attention, right? So, you have to bill for your full time. It's quite the ordeal sometimes. So that, of course, is going to be one of your considerations. But what would be the reasons to take the deposition of, your opponents? Well, a deposition is kind of like a practice trial in some ways, right? You're going to put somebody on the stand, although there's no judge, there's no courtroom, but they're going to be under oath and you're going to be asking them questions. So you're going to see, one, what responses you get so you know how to prepare for trial, and two, what kind of a witness this person is going to be at trial. So if it is the kind of case that you think is likely to go all the way to trial, it may not settle, and you're not going to get a summary judgment, harken back to my summary judgment episode for details on that, then yeah, you probably are going to want to do at least one or two depositions because you don't want to go into trial blind. And now that I've brought up the prospect of a settlement, listen, nobody likes to be deposed. I don't know anybody who likes to be deposed. It's kind of nerve-wracking. You're under oath. You got to be very careful. So you got somebody typing down every word you say. Some people are going to freak out. Just the prospect of being deposed and having to go through that may prompt a settlement. But that's probably all I need to say at this point about taking a deposition. Those are, only things you really care about. So let's turn our attention then to defending a deposition, right? I mean, if you're a party in the case, or even if you're just like a witness, somebody with information, you could end up having to go through a deposition. It's not your choice. The other side subpoenas you and you got to show. So, anytime you're in a lawsuit, I think you need to have in the back of your mind that there's certainly a very decent chance that you're going to have to go through this ordeal. All right, part 2, we've got a lot of territory to cover. I'm breaking this into 2 videos, so let me go ahead and start from the beginning. Well, who are the key parties to a deposition? Let's get some of the vocabulary out of the way. The person being deposed is called the deponent. That's you, my client. Another key figure is going to be the court reporter. This person is going to be the one who's listening and taking down every word that's being spoken. Usually the court reporter will also swear in the witness, and if it's an online, remote deposition, which is very common these days, thankfully, then usually the court reporter is the one who handles the technical aspect of things. You got your opposing counsel, of course, and if we're defending the deposition, it's his or her show. It's their deposition. They're going to take the lead on everything, and that is going to be the dynamic throughout. So, don't be expecting that your attorney is going to be super active. At least not our. It's not our style to do so, and I'll explain why. And that brings me then to the last person in the room, which is going to be your attorney, of course, your HLA attorney. Now, why is it I would say that if we are defending a deposition, you shouldn't expect us to be super active? Well, ideally we're not. If we are very active, then that means things are going wildly wrong. Well, as a practical matter, we're not the ones asking the questions, right? It's not our show. We're just there to make objections. Now, I will have much to say about objections, but I'm going to make that part 3 of this episode. First, let me bring up something that I probably should have brought up previously. Another reason why you may want to do a deposition or why your opponent wants to depose you is because these people who are constantly changing their story, especially if they know that they're probably on the wrong side of the law with this lawsuit. They're going to want to be fluid and, change the facts as they go. Well, you take a deposition, you lock them in. They have to take a position, right? Everything goes down on paper. And then that will lead you to ask, well, okay, so I'm the one being deposed. Now, what if I get something wrong? What if I make a mistake? I misspeak in some way? Okay, well, it is actually not the end of the world. The depo will have the effect of preventing you, or whomever, the deponent, I should say, from constantly changing the story. They're going to have to pick a narrative and go with it probably throughout the rest of the trial. However, what if you do misspeak? It's not the end of the world. For one thing, after the deposition, if you order the transcripts, which tends to be expensive, but if you order the transcripts, you'll have a chance to go over everything that was asked and all of your responses. And if you see that you may have misremembered something or misspoken in some way, or you want to clarify something you've said, there's something called an errata sheet, and you'll have an opportunity to do that. Besides that, listen, you can show up at trial and explain yourself. Say, well, you know what, I thought this at the time, and then I went back and checked, and that wasn't correct, or I misunderstood the question. Okay, now, are you going to get the famous, well, were you lying then, or are you lying now? You may get that, but as long as you can explain yourself in a sincere way that makes sense to the judge or the jury, then, it's not a killer. Here we go with part 3. Okay, now, listen, if you're looking for the kind of attorney who's going to be jumping out of his seat all the time and insulting the other attorney and just interrupting the proceedings the whole way through, listen, it's kind of fun. There's a famous guy in Texas that was famous for doing that sort of thing. He was hilarious, but if that's what you're looking for, we're not the attorneys for that. And I'll tell you why. As a practical matter, the less time you spend under oath being questioned, the better. So we really would like to just get you in and out of there as quickly as we can. As another practical matter, the more disruptive we are, the longer the whole proceeding is going to take, the more expensive it's going to get. You're going to roll into multiple days. I mean, I don't want to do that to you. I don't see any benefit, besides potential entertainment value, it's not going to be worth it to you to do that. Also, in that same vein, the longer the deposition goes on, the more tired you're going to get and potentially more frustrated you're going to get with the whole process, and you're more likely to make a mistake or something's going to go wrong. So, counter to what you might be thinking, that you want your attorney there, you're paying good money to have your attorney there, this person should be very active, they should be protecting you. Not really. The more quiet we are, the more quickly and smoothly things are going, the better. That's a good sign. In fact, there may be occasions when there's an objection that I could make, a valid objection, that I'll just refrain from making because I like the way things are going. I don't want to break up the rhythm. Let's keep it moving. I don't feel like you've said anything that does any harm to the case, so let's just keep it moving. Okay, so, let's get to the meat of the episode now, which is objections, actually. And there are lots of technical objections that can be made. There are lots of rules of evidence, which you may or may not understand. Let's take a very famous one, hearsay, for example. As human beings, we're all very susceptible to just, blurting out something that comes to mind, whether or not what we're saying is based on personal knowledge. It could be something that we heard from somebody who heard it from somebody else, and you just you may have good reason to believe it's true, but that's hearsay. That doesn't count. So as a deponent, you can only give testimony as to your personal knowledge, something that you personally saw, heard, or did. Those are the only things you can testify to. Now, it's a very natural thing for us to give hearsay testimony or just in real life. So your attorney you can hear your attorney pipe up, actually objecting to something you said, which is maybe a little off-putting. But if you say something that I know is hearsay, that I'm going to make that objection, it's not a big deal. It just needs to be put on the record so that your statement can't be used against you later on. Just move on, though. Okay, let me turn this around. Most of the time when we're making an objection, it's to the question that you're being asked by the other attorney, right? We don't like the question. There's something technically wrong with it. Well, usually the attorney will then rephrase the question, but even if the attorney doesn't wish to rephrase the question, you still have to answer. The objection gets put on the record, and before anything you say then can be used in the case, a judge would have to decide whether the objection was valid or not. I bring that up because unless I or your attorney specifically tells you not to answer a question, don't be put off by an objection. The objection is going to happen, and then you're still going to go ahead and give the best answer you can. Now, let's get into the fun part a little bit. Okay, gamesmanship. Now, what I just said is true. Most of the objections that we make are going to be technical, and you just, then get on the record and you move on. You can give the best answer you can. But with that said, bear in mind, we're not allowed to actively coach you during these depositions. So it could be the case that when we make an objection, we're trying to signal something to you. What I mean to say is this. Remember, for the most part, the HLA attorneys are going to try not to say too much. We want things to just flow smoothly and get the hell out of there. So when we do pipe up, there's a reason for it. So I want you to listen very carefully to the objection. If you understand it, and many times you will understand what's being said, I want you to think about what you were just saying, or the question that you were just asked, and I want you to maybe, well, be careful, right? Perhaps modify what you were going to say based on my objection. Or at the very least, understand that this is a moment for you to be alert. Let me give you a couple easy examples. Now, sometimes the attorney will ask a question, will ask a bad question, right? Maybe he or she is asking you to speculate on something. Well, you're not allowed to do that, right? And that is the basis for an objection. So you're going to hear objection, speculative, or speculation, right? So again, I may not even make that objection even when I could, but if I'm taking the time and I'm breaking up the flow of the questioning to make that objection, it's because I don't want you to speculate. See what I mean? Well, here's another one. Asked and answered. So what I'm saying to you when I make that objection is this attorney is trying to get you to change your answer, or this attorney is trying to get you to guess at something when you've already told them you don't know or you don't recall. And by the way, those are perfectly valid responses. I don't know or I don't recall. Sometimes attorneys will ask you the same question in many different ways because they want you to change your answer, or they want you then to go on the record guessing because you might guess badly, right? And then they can use that against you. So when I detect that, I'm going to say objection, asked and answered. And what I'm saying to you is don't change your answer. Don't allow this person to bully you into saying something different. And for the love of God, don't guess. One last example. I may object to the form of a question. I might say it was vague, it's confusing. And again, if I'm now breaking my silence and slowing down the proceedings, it's because I think it's important enough. I don't like the question. And what I'm trying to say to you is don't interpret that question however you want to, require this attorney to ask you the question in a clearer way. And because remember, I've already spoken with you. I know the facts of the case, at least from your point of view, and I've already filed things with the court. So I also don't want to be surprised by your answers. That is as far as we will go with this one, as I promised. I mean, there's a lot to be said about these depositions, but it is very interesting. It's tedious, and as little as I like going through the ordeal, they are interesting and useful. So, recuerda que hablamos español, and I will talk to you guys. Well, do the stuff down there, please. Hit some, make a comment, do something, help me out here. And we'll finish up depositions next week. See you then.